had they provided an adequate investigatory method when he first complained, not only would it had stopped then, those officers would have been dealt with as they subsequently were, but Mr. Todd would not have been put through the additional 2 years of very hostile conditions to work with.
But if the Trump report says that all those things are valid, then what do you need then that they will be valid?
Well, we need to be able to present that evidence. We need to be able to talk about that evidence in court, that this is what he complained about.
You have that report, right?
Not all of it.
It's been a while, so I can't say I have this all crystal clear.
Sure.
You have a redacted version of the report.
And what's been redacted is the very conduct that Mr. Todd was complaining about. We're seeking to unredact. We're seeking now the entire report.
But if they stipulate, and I'm just thinking loud here, but if they stipulate that, the report, that they're not challenged, if their position is, oh, we think he made it all up and none of that stuff is true, then that might change my view. Are you arguing that? I guess before I go further, I should find out.
We're going to stand by the Tremblay report. The only parts of that report that were redacted were done so at the request of Attorney Monahan related to the alleged sexual improprieties related to former officers Johnson and Post. The rest of the report.
So you're not going to deny that the reports he made were valid?
Well, I disagree with Attorney Fagan with regard to what the scope of the Tremblay report's conclusion. Some parts of what Mr. Todd complained about were validated, some parts were not. It's a bit more complex than that.
Okay.
Some of the things about which he wants to complain here were not raised, like so-called abuse of canine. That wasn't raised at the time. That's been added since.
Okay, but I guess my question is just, is part of your defense at trial, should we get to that point, hopefully eventually, is part of your defense going to be, he was reporting all kinds of stuff that wasn't true, and that's, we thought he was a liar. I mean, is that going to be part of this or not?
No, I agree with the court, Your Honor, that the validity, the truthfulness of what he raised is not the issue. So if he raises issues about whether or not an officer was having sex on the job, whether that officer was having sex on the job, I don't believe is part of the trial. He raises an issue. The next thing
Well, unless, and that's why I'm asking, unless your client's position at trial is going to be, he reported all this stuff, it was all false, he was a pain in the neck because he kept making stuff up, that would be a different story. Then it might become relevant. So that's why I don't know enough about your position at this point to know where you're headed in your defense. So I need some clarification on it.
our position is that, well, there's some disagreement about what he raised when, putting that to one side. We don't believe he was retaliated against.
I know that. But are you going to say he was lying about the stuff? I mean, is there a point at which he may need to prove that some of it really was true or that he had a valid basis for it?
Well, those are slightly different questions.
True. Fair enough.
We are not saying in this case that Mr. Todd is lying.
Okay.
We're not. There are some matters of which some issues he raised that the Tremblay report validated. There are other issues he raised that the Tremblay report concludes it can't conclude. There's inadequate evidence. There's other parts which weren't substantiated as
But I guess what I don't really know, I mean, it's, when you're sitting where I sit, you guys all know way more about this case than I do. What I don't really know is, when we get to trial, what Mr. Todd is going to be claiming about how he was being treated that led him to quit. I don't really know that yet. And so I'm just trying to find out if part of what may come out is he's going to say, they were all giving me the cold shoulder or whatever, and your witnesses are going to say, yeah, because he was making up all this crap about us. And if that's coming in, that I may need to take that into account. That's what I'm trying to figure out.
Well, that goes back to the court's legal analysis, Your Honor. Would Johnson and Post say that they disagreed with things Mr. Todd raised? I can't answer that, but it wouldn't surprise me if they did. But that's different than the question you're posing to me. I go back to your initial legal analysis. The case, I don't know the citation to the case that Attorney Fagan is referring to. I don't have a copy of it. But as I listen to him, that's a case on a federal analog to FIPA.
Right, it is.
It's not a public policy issue. As the court was saying in the public policy issue in your hypothetical, whether or not the things you allege are true, I don't see how the truth of the allegation is relevant. What matters is whether or not you were retaliated against for raising issues that are, one, rise to the level of public policy. You can't just be things that the Supreme Court says doesn't rise to that level. But if it does rise to that level, were you retaliated against, et cetera, et cetera. The truth of the allegation about whether or not, to use the court's hypothetical, some member of the judiciary was driving under the influence is not something that needs to be proved. The only thing that needs to be proved is that you raised the issue.
Mr. Monahan, do you need to weigh in on that issue before I give the floor back to the plaintiff's counsel?
I would, just subtly, Deb, thank you. So, as you've defined, I represent Post and Johnson,
Right.
and they would disagree with at least some of the characterizations of their behaviors in the report. But I want to be clear that I think we agree that what really matters for Mr. Todd is really whether he raised the issue. He does not have to prove the substance of what he's alleging right now in the court. He just has to allege that he made a complaint and that there may have been action one way or the other on it.
All right, so do you see where I was going with that now?
I do, and I think maybe this would be more responsive to the court's inquiry, because as that case teaches, the Perry versus Ethan Allen, one of the critical inquiries in a hostile environment claim is evidence of general workplace environment. So how or why would, for example, shocking a dog unnecessarily be part of it? Because...
Okay, but wait a minute. So you're mixing things here, right? This case is about discrimination under Title VII, which is analogous to your FIPA claim, which is a racial discrimination claim. That is different from the common law public policy. I mean, I think we have to separate them. You know, this is talking about what you have to prove for a claim of racial discrimination, not the public policy thing.
actually, the analysis is identical, because what you're claiming is a hostile work environment because of complaints made in either case. And in the public policy, it's no more, the analysis is exactly the same as if you're claiming sexual harassment or racial harassment. In other words, the court say, what were the conditions of your workplace after you complained about these matters that made it hostile? You've got to show us hostility in the workplace. That's why they say, we need evidence of what the general atmosphere...
Was Perry a retaliation? I don't know that it was a retaliation case. I don't think so.
Well, it talks about what has to be shown in order to show up. We claim a hostile work environment as a result of complaining about issues of public policy.
I think that's different, though. I mean, a hostile work environment under Title VII or FIPA is, you know, I mean, the sort of standard traditional one would be, you know, the woman who's working in the factory and the men are all putting up dirty pictures and telling dirty jokes and, you know, using crude language that would be offensive to her as a woman. I think that's sort of the genesis of the whole hostile environment case law, right? Is, you know, making it unpleasant for someone to work in a place because of a protected thing. In that case for gender, in this case is race. You know, if they're walking around using inappropriate terms for, you know, people of his race, if they are insulting the clientele who come into the police station of his race, you know, that's a hostile environment because it's based on race, which is the thing that is protected under that statute. If they were kicking dogs, that doesn't go to a racial claim.
No, but it does go to violation of public policy and a subsequent retaliation creating a hostile work environment.
But that's what, I think I'm not sure where a hostile work environment comes in at all under a public policy claim. I mean, your public policy claim is he properly reported things that we want people to report. That's where the public policy thing comes in. And then they treated him badly.
They retaliated.
But are you saying so what did they do to retaliate? What is your claim? I guess maybe that's...
Right. They retaliated by creating a hostile work environment. For example, he complained about the fact that Post was unnecessarily abusing his canine. Okay? Post, the evidence...
His canine or Post's canine?
Post canine. Okay? The evidence will be that Post sat across the squad room from then Corporal Todd and would look right at Todd and shock his dog as if to say, you complained and there's nothing you can do to stop me. These are the kind of circumstances that the courts make clear juries have to be aware of so that they will know. When Corporal Todd actually saw Sergeant Johnson having sex on the shift and he complained about it to the lieutenant, okay? Sergeant Johnson began to short shift the plaintiff. By that, he began to fail to replace people that were out. Again, creating hostility.
And so I agree with you, if that's your claim, I agree with you that your client can testify, you know, this is what he did, that he sat there shocking the dog after I complained. But I don't think he has to prove that he kicked the dog before, or he shocked the dog, right? And the substance of his reports, I don't think he has to prove they were true. He just has to prove he made a report and then someone did something to him. That's what I'm saying.
Okay, well, if that's going to be the law of the case, I'm pleased to accept that law, Your Honor. But I do understand you're saying that if the defendants are going to contest any of the underlying conduct he complained about, that we would then be required to prove it?
Well, I'm trying to figure out how that's going to work. I mean, I don't think, I mean, this trial, it should not be about, you know, were people having sex on the job, were they kicking dogs, whatever. You know, the focus is on your client and how they treated him.
But their motive is important, Your Honor. In order to establish that he was retaliated against, we have to be able to show the jury that they were motivated by him.
But it's by him reporting it, right?
Well, no, it's actually that, yes, but then the actions they took against him after they found out he had reported them.
And again, I mean, I have no problem at the, you know, I mean, I can't rule in advance about everything I'll say at trial, but, you know, in the abstract, I have no problem with him testifying about whatever he says they did to him to punish him after he reported. I mean, I think that's appropriate, and, you know, they can dispute those things. I mean, the guy can say, I never shot the dog, and the jury will have to decide who they believe. So, you know, the post-complaint retaliatory behavior you certainly have to prove, or at least enough to convince the jury. But I don't think it matters one way or the other whether the other stuff is true. And again, unless the defense in this case is going to be, the guy was a wacko, he was making up all kinds of crazy stuff, that's why we didn't like him anymore. And I'm not hearing that. Am I correct from this side of the room?
You're not hearing that.
So, you know, could something change at trial where I say they open the door to something? Yes, but I can't.
Sure.
At this point, it sounds like we can trust that.
So there, and just to round out that conversation, there are numerous officers that have testified to the same types of things. They knew that these two officers were lying in official reports. I'm not, again, trying to prove whether or not they were lying, although the proof is there, but again, that's evidence of the general work atmosphere that everybody there knew these two renegades were engaging in these behaviors, and all of the angst about that was by management directed at Mr. Todd.
But I don't think that, I mean, we've all worked in workplaces that weren't pleasant, right? You know, I assume. We're all old enough, except maybe Mr. Todd, but there was, and maybe, but some of us. You know, I worked in a horrible pizza shop when I was young, right? It was awful. I hated the way people treated everybody. It wasn't illegal. It wasn't, you know, it wasn't because of my race. It wasn't because of my sex. It wasn't because of my age. It was just a bunch of jerky guys, okay? The fact that the workplace is unpleasant is not per se a legal issue. If it's unpleasant because they're directing it at his race or they're punishing him for reporting things, that's illegal. So the fact that there was all kinds of, and it sounds like it was an interesting place to work. I will certainly give you that. But the fact that there was stuff going on that shouldn't have been going on really isn't directly relevant to the legal claims unless it has to do with race or retaliation for reports, is what I'm saying.
And that's what we focused our attention on, is to show the things that were done to then Corporal Todd in retaliation for complaints on both of those fronts. Yes, Your Honor.
Okay, so.
The next issue that we...
Hold on 1 second, because it looks like I have something you'd like to...
I just want to focus on what Attorney Fagan just said.
Yeah.
What Attorney Fagan is trying to do is take a morass of disputed, or a morass of environmental issues, and then somehow claim that they're all related to the public policy and the race. What's related, what's retaliation, if you will, and what was just an unpleasant work environment is going to be a huge issue at trial.
I can see that, and I'll have to make a lot of evidentiary rulings, I think, as we go.
That's what I'm trying to highlight, is that one of the areas of focus going into the trial, and at trial, will be what is relevant, what's admissible, and what's not. what is in retaliation.
And there
what
may be
is-
some motions in limine that are appropriate in advance of trial, or some of that, I don't know.
Oh, it'll be a lot of motions.
Okay. Okay, but right now we're just talking about discovery. And so having had this conversation, Mr. Fignan, are you asking for something further on that issue?
What I would like to do, Your Honor, and for the record, the plaintiff would withdraw his request to redepose Johnson and Post. That was one of the areas, but we're satisfied with our examination. We don't need that, and
Okay.
so I don't want to ask for something I don't need. And I'm sorry, your question was?
Hold on one second, I just want to make a note of that. I'm at the age where I gotta write everything down. My question was, this whole conversation, I think, started because you were asking for additional discovery about some of those other incidents. And having had this conversation, I guess I just need to know where you stand now on whether you feel you need more discovery.
So there were two remaining depositions. The deposition of Christopher Loris, the mayor, and the deposition of former city attorney Andrew Costello. And yes, plaintiff would like to inquire of those individuals about these complaints of bad conduct and what would have been an appropriate response to them. So up until now, we've been precluded from asking specific questions about those specific instances of bad conduct. But the case law makes it clear that it goes to what they knew when and what was done about it and whether what was done about it was appropriate. And I think that as we've gone up the ladder of authority, those are particularly appropriate questions to be asked in the mayor and the city attorney.
And I'm sorry, what case law are you referring to? I'm not sure. I didn't quite follow what you meant. What case law are you referencing?
The case law we previously submitted as to whether or not the employer has, and it's talked about in the Ethan Allen case, whether or not the employer appropriately responded to the complaints, and if so, what was the response and why was that response inadequate?
And do I understand that well, obviously there was some investigation done and a report written.
A couple of investigations whitewashed it. The final investigation confirmed it.
Okay. But so, what else is it beyond an investigation that you think should have been done?
When the investigation, what should have been done, and if the investigation had been conducted properly, what would have been the sanctions? I mean, the employer is under an obligation to take immediate action to investigate claims such as this. They didn't do that. And so the inquiry would be, should that have been done? Do you know why it wasn't done? Were you aware of A, B, C, and D? Had you known that, don't you think it would have been appropriate to do A, B, C, and D? This goes directly to the city's knowledge of what was going on and their failure to address it.
What's your response on that?
Several matters, you know, initially as briefed, what we're hearing here is a little different than what we're briefed. As briefed, what Attorney Fagan wanted to ask Attorney Costello about was a series of issues and events that arose after Mr. Todd left the city's employment. So this is a bit of a shift here with regard to Attorney Costello. Attorney Costello, you know, obviously the city attorney at the time. I don't believe he can be deposed, should be deposed, is legal
When did
advice.
he come in?
Pardon?
When did he come in as city attorney?
Interesting question.
Okay.
I believe it was, when was Mayor Warren first elected?
Anybody know?
Yeah, so in 06, 07, in that.
And you left in 12, right?
Correct.
Okay, so he was the attorney at the time.
He was the city attorney from the time that Mayor Warren was elected through sometime after Mr. Todd's departure. I believe he left sort of in spring of this year, if I remember correctly. I might get my
But
dates
your
wrong.
point is that,
This year or last year? Last year, 13.
but your point is that you were saying he can't be asked about what?
Well, to begin with, there's the time frame issue. Whether or not things that took place after January 2012 have any purpose. Because one of the big issues that Attorney Fagan wants to ask about are his concerns about, you know, who the Tremblay report was shared with, who down to see it, Attorney Costello's advice on that stuff, that all postdates Mr. Todd's department. So there's the time frame issue, and that is a very substantial issue. We believe that the pertinent time frame is what happened, if anything, before January of 2012. Then the second area is that I don't believe it's appropriate to be asking a whole lot of hypothetical questions to either Attorney Costello or the mayor. Well, if this and if that, what would you do if this, if that? What would the city's official position be on a series of hypotheticals I'm about to throw at you? Is the mayor a witness in this case? Frankly, yes. But he should be a witness on what he said, what was said to him, and what he did about what was said to him and when it was said to him. So he ought to be a witness in a fact witness sort of sense, not a whole series of hypotheticals on what should the city's position be if X, Y, or Z. Related to that, one of the areas of consternation or disagreement at depositions have been Attorney Fagan's penchant to ask people to ultimately legal question in the case. Wouldn't you agree if somebody said X, that's a hostile work environment, meaning the legal conclusion was something's a hostile work environment? And I don't think those questions should be allowed either. It should be fact witness depositions asked what they saw, when they saw it, who said it, not a series of hypothetical legal questions.
Okay. I'm trying to remember now, were these two folks deposed at all, and you want further deposed, or they haven't been deposed?
They have not been deposed.
All right, so what about his point, first of all, that you're really trying to use them as experts and give you hypotheticals?
So part of their job responsibility is agency heads, and I did plan on addressing the Costello deposition separately, Your Honor. But as far as Loris is concerned, he's charged by statute and ordinance as the chief executive officer of the city. He's responsible to know what could create a hostile work environment for any person who's in a protected class. So the questions wouldn't be hypothetical. The questions would be, Mayor, if you knew this, that, would you think that might create a hostile work environment?
How is that admissible? I mean, that's going to be the jury's decision.
Well, because it reflects back on what they did and didn't do when they had that information prior.
But that, I mean, those questions are fine, you know, what did you do?
Right.
What did you do?
That's all I want to ask him. But I want to ask him in reference to the specific conduct we know has been shown, that we know they knew about.
But do you? I mean, do
Yes.
you know that
Well,
they knew about it?
as a preliminary matter, we'll ask him, but they've published statements, both Costello and the mayor have published statements saying that, especially with regard to Costello, that he's intimately familiar with the details of the investigation and that he's compared it to the allegations of this complaint. He finds no merit. So certainly factual questions as to...
Let's keep them separate. Lourdes, so why isn't it appropriate for them to ask what involvement he didn't have, if any?
I think I just got done saying that what he said or what was said to him is fine. It's part of the
Okay, so
objection.
you're not opposing his deposition as to what he actually did or didn't do or see?
Correct. What
Okay.
I'm opposing is the effort to go beyond that and do what the court's calling an expert deposition, but which, is an effort to question him about the ultimate legal questions in the case or a series of hypotheticals.
Right, I mean,
If you posted this, wouldn't you agree you should fire kind of stuff?
I would agree that that would not be the way to ask the question, but I think certainly he could be asked, have you been trained in it? I mean, things like that. Have you had training in hostile work environments? What training have you had? Did it give you specific directives on how to handle a situation? I mean, specifics to his own experience or training in the area is fine, but I agree. If you want to ask hypotheticals, you probably need to hire an expert witness.
I have an expert here. Thank you.
Okay, so Lourdes can be deposed, but let me say this, since I know that a lot of things lead to fights in this case, I am happy to be available by phone if there's a dispute over something like this in the middle of a deposition to just pick up the phone and call. If I'm available, I mean, it depends what I'm doing, but generally I can break and take a couple of minutes. So if you guys have problems, you might want to alert the staff here in advance that you're doing a deposition on a certain day, and you might want to call just so I kind of have a heads up about it. And we can tell you if I'm on vacation or something, but I do offer to try and sort that stuff out. But I think from this discussion that we're probably all pretty clear on So Costello, you said you wanted to address separately.
Yes, but before, could I address the comment about no evidence being allowed after January 12th?
Sure, yes.
And the reason that's problematic, Your Honor, is because subsequent to January 12, my client received a death threat from defendant Post. Subsequent to January 12, and many officers have testified that's a threat should be taken very seriously. After January of 12, the Tremblay report was issued, and the city did what it did with that Tremblay report. It's our position they were...
What did they do with it?
Nothing, they hid it, Your Honor. It's our position that they were obligated under city ordinance that we previously cited to the court to share that with the police commission, which is charged with reviewing and governing the police department. And we've also taken the deposition of a police commission member who said they do talk about IAs. He doesn't know why this IA was not shared with the police commission, and he thinks that it should have been. All of that behavior happened after January of 12. Now, the defendants have just recently disclosed Thomas Tremblay as their expert, and they're telling me that they're going to rely upon and they reference his entire report as the basis of his opinions. For no reason other than that, the conduct after January of 12, including Tremblay's involvement, has to be at least allowed to be discovered on.
I don't think anybody's disputing the report can be, because it relates to these events, right? The report can be discussed. It sounds like you guys are going to be doing that anyway.
I just want to be clear, there are some nuances between the city's position and my client's position.
Okay.
And we produced a redacted copy of the internal affairs report because there are certain things in there that we felt at the time of the discovery request were outside the scope of the case. And we still feel that way. And to the extent the city wants to disclose all that stuff, I can't agree to that. We don't agree to that.
An unredacted version.
Correct.
But do you know your position on that issue yet?
On the redaction?
Yeah.
The redactions are related to the sexual allegations, Your Honor. That goes back to
So
January.
you don't have a problem with using a redacted version?
No.
Okay, so it sounds like the issue won't be between the two of you, but between two sides of the room for me to sort that out later.
To begin with, the alleged post-death threat happened shortly after.
I'm not talking about that yet, I'm just saying the report. It sounds as if both sides are going to want to talk about the report in one way or another in the trial. Is that fair to say?
I suspect the report is going to become a subject matter at trial. We disclosed Mr. Tremblay, if you will, as a fact expert. That is, he did a whole lot of investigation, research, and conclusions about whether or not there was racial profiling. So if racial profiling becomes an issue at trial, then it's inevitable we'll get into Mr. Tremblay's opinions on that subject. Was he disclosed as a retained expert? No. He was disclosed so that I wouldn't get into a quarrel with Attorney Fagan over a fact that
Okay,
was
well,
already
let's,
made.
putting aside the report itself for the moment, my question is if we assume that that's not part of the discussion, what relevance do other things that happen after he's already left have to proving his claim of that he left because of these other things? I mean, he says I was constructively terminated for these reasons, but he's gone now. So how can those things be part of his proof?
Because they show that had they investigated like they should have when he first complained, that those subsequent behaviors after his complaint would never have occurred, he would have never been subjected to it. And all of the statements that Tremblay takes are after January of 12. So you can't allow Tremblay to testify because of all his activities after January of 12 without giving plaintiff an opportunity to inquire about post-January 12 behaviors as well.
So tell me exactly what post-January behaviors you're seeking to inquire about?
We're seeking to inquire about, obviously, the content of Tremblay's report.
But you have that.
We don't have it all.
Okay, but you have, but for the redactions you have.
Yes. Okay. And ask the mayor what his training was to review a report like this, what he thought was done with a report like this, And more importantly, why wasn't this shared with the police commission? Because part of our claim here is that there was a conspiracy to hide the racial information that was in that report. And obviously that goes to the heart of continuing the racial harassment and discrimination against my client. They had a duty.
But how can they be still discriminating against him when he doesn't work for them anymore? They're not his employer anymore.
Because they're continuing to cover up what he was subjected to, and they're continuing the misconduct that was visited upon him. All plaintiff ever wanted, and the Ethan Allen case makes it clear he was entitled to, is he wanted to know what was done with his complaint. They would never tell him. Even when he filed this lawsuit, they refused to tell him until we got an order of the court. He was entitled to that. So it's under the theory of continuing wrong, which again, the Second Circuit refers to in Ethan Allen, that evidence becomes at least discoverable, Your Honor. At this point, we're going to argue later that it would be relevant, but it's certainly calculated to lead to discoverable information.
Can you show me in Perry what you're referring to? And by the way, I would ask that you bring copies for other counsel.
You know what? It was on a separate pile and I just spaced it. I'd like to grab it for you.
Could I at least have a citation?
No, yes, of course. 115 F 3rd 143.
So if we go over to page 7,
Yes.
under, there's a subheading A, the in limine ruling. The next full paragraph over, the court writes a couple of sentences down. The district court, however, noted the possible application of the continuing violation doctrine. And we've actually alleged that in the complaint, that there is a continuing violation of my client's rights with regard to what he complained about and what the city continues, the behavior the city continues to engage in, which is an attempt to deny that and cover it up.
But this case, if I'm not mistaken, the Perry case, the continuing violation doctrine referred to whether some earlier claims were barred by the statute of limitations or not. We're not talking about claims post her working there.
Well, but the reason, the approach is the same. If there's a continuing violation, then that's a sufficient grounds to allow at least discovery on the issue to be able to show you how it might be relevant at trial.
I'm just having trouble, you know, I mean, if I breach a contract with you on March 2nd, and I send you a nasty letter, you know, a month later saying you're a jerk, so what? The case is about the breach of contract.
Well, actually, Carmichael speaks to that. There was a breach of contract, and after the breach, the breaching party tried to keep other people from doing business with them. And under that theory, if you breached it and you continually breached it, even though the contract was now done, because your behavior was still interfering with the spirit of the bargain. So it's not unusual for evidence after the particular event. For example, in an automobile crash, people make statements after the event that say, yeah, you know, that light really was red when I went through it. But that should be allowed to come in. It shouldn't be tied arbitrarily to a date. It could be relevant under certain circumstances. What we're asking for is an opportunity to discover this information as reasonably calculated to lead to admissible evidence and present that to you in a fashion that allows us to point specifically to what we have found out. I mean, if we're not allowed to discover on it, we might not ever we'd be deprived of an ability to be able to argue its relevancy later on.
So again, be specific. You want what beyond the report? What are you looking for? What
I want to know why they haven't just admitted these things, why they didn't just give a copy of it to Andy, why do they continually say that there was no merit to his complaints when they know differently?
But those are sort of, I mean, I don't have a problem with you asking them, you know, who did you give the report to, when did you give it to them, what actions were taken as a result of the report. All of that, I guess I can be convinced might become relevant. But all this, you know, why stuff, I'm not sure where that goes. That's a little different.
No, I appreciate that guidance, and I can conduct my inquiry to the court's regard in that regard. But
So who is it that let's be specific, what are you asking to do? Are we talking about a document request, a deposition?
Deposition.
Of whom? Is this
Mayor.
Lord's? This is part of the Lord's deposition?
Mayor Lawrence, yes.
Okay, and just asking, when did you get the report, who did you give it to, that sort of thing?
What did you do and why?
Any issue with that?
This ties back into, Your Honor, the redaction of the Tremblay report.
Mhm.
So there's two issues. One is who the report was given to and why was based upon Attorney Costello's advice as to his understanding of the law at the time with regard to the privacy interests of Johnson and Post. So what Attorney Fagan is really trying to do is depose other witnesses about Attorney Costello's advice. Because Attorney Costello is the one who gave the advice about whom the report would be shared with and whom it could not. And that was based upon his analysis, pre-Rutland Herald cases, of what the privacy interests were of Johnson and Post, and at the time that internal affairs reports were deemed confidential, and who could you give this personnel information to. So there is that collective set of issues, and what this is really a backdoor effort to depose the mayor on what Attorney Costello's legal advice is.
Well, that would be privileged, and I think I've ruled on that. I mean, the mayor may say, you know, we gave it to the people we gave it to because that's what our lawyer told us to do, and that's where it should end. And on the issue, I know that you were also raising in your motion the claim that the court erred because there is a defensive advice of counsel in this litigation, but I don't see them proffering that as a defense.
Well, the advice of counsel is on who the report can be shared to, and Attorney Fagan wants to turn that into into something that Mr. Todd asked damages for in front of the jury. I just don't see how that could ever begin to be relevant.
And none of that happened while he was still employed there.
Correct.
Yeah, so I don't see it coming into evidence.
Right, the Tremblay report addresses issues that took place, or disputes that
That
took place
happened when he was still there.
before. Correct. So that's the slippery slope of the report itself. But in terms of what's done with it, that's all after Mr. Todd left.
Right.
And so who it was given to and why, I do not see how it could begin to be relevant.
You want to respond to that?
Yes, Your Honor, it's part of our theory that they're continuing the very misconduct that they started with Mr. Todd. But I want to speak to Attorney Costello because we provided the court with sufficient law to show that when a witness raises advice of counsel, as Baker did, he said that he was not going to tell me why he didn't give the report to the police commission based on advice of counsel. We briefed that issue. When a witness raises that defense, we're entitled to test what that advice was. More
Are you
important.
talking about in your motion to reconsider that you cited?
Yes, it is.
Okay, let me just find that. Greg, would you get me 147 Vermont? Looks like that's the case you're referring to.
I actually have some additional authority for your consideration this morning because I was able to find a federal court decision by Judge Sessions in which he took the unusual step of overruling the magistrate's decision that the attorney-client privilege and work doctrine protected plaintiff's inquiry into legal action against their employer. That case is Peterson versus Wallace Computer Services, Inc. And it's cited at 984 FSUP 821, District of Vermont, 1997. And the court went on to show that an employer may defend itself successfully against a hostile claim by demonstrating the adequacy of its response to plaintiff's complaint. All right, it went on to hold that in order for the plaintiff to establish hostile work, they must show that the employer provided no reasonable avenue for the complaint or knew of the harassment and did nothing about it. In supporting the fact that the employer chose to use an attorney to be part of the investigation did not in any way diminish the plaintiff's right to have that investigation and to overrule the attorney-client privilege. And they're citing some Second Circuit law from 1992 in doing that. What we're saying here is that when Baker says he did not share this information with the police commission, information that the police commission says should have been shared with it, we're entitled to test that and find out from Attorney Costello directly, was that his advice?
Well, I
I
might
think I've been
agree
pretty
with
clear
you.
on that.
Sorry, what?
I think I've been pretty clear on that. Attorney Costello's advice when the Tremblay report was issued was that it could not be shared with the police commission or generally because internal affairs reports at the time were considered confidential personnel matters subject to personnel rights of those officers, Johnson and Post. And that to whom those reports could be shared was very limited. It could be shared with Johnson and with Post, but not Mr. Todd, which is what he's so upset about. But that's because of Attorney Costello's view of the law at the time about who could be shared with and what privacy interests would be implicated if it was shared further. I don't see how this legal debate.
But this was after he'd already left, correct?
Yes.
So I don't see how, you know, he's already suffered the harm. He's not working there anymore, he's not getting paid.
He's continuing
The
to suffer.
wrongdoing occurred when he was constructively terminated.
The wrongdoing continues, Your Honor. He's still in law enforcement. He's still being shadowed by all of the talk going on that none of what he complained about was valid. And
Well,
that,
that may be true, but that's not a legal claim, okay? I mean, that's a reality, and it's a practical reality, but that's not part of his legal claim.
well, it is if it's being perpetuated by the defendants, Your
Under
Honor.
under what law?
Both under the continuing wrong theory, both
I mean, I just
under our conspiracy theory.
I don't think that you can, I don't think there's any law to support the idea that a wrong that's led to termination, there's some independent, I mean, new claim post-termination about all the bad stuff that's happened since. I mean, the harm he has to prove to win this case is that he was fired constructively and he lost whatever he lost. And some of that may go to his damages, certainly, you know, if he's making less or whatever. But we don't bring into trials all these things that happen after the wrongdoing that, you know, leads to the.
But the wrongdoing continues is my point. This is a
Well-
continuing wrong. It's no different
But I don't
than.
think there's any, if you can give me some law to support that, I guess I'll think about it, but I'm not aware of it. But let me look right now, I just know, you cited the Steinfeld versus Dworkin case about the attorney-client privilege, and I just want to review that. Okay, that case was about, whether a settlement had been approved between a client and a lawyer. I don't quite see that it's directly relevant here. But my understanding of the law, when I did the initial ruling, and I'll look again at the cases you've cited in your motion to reconsider, but was that the fact that a witness at a deposition cites advice of counsel is not the same thing as a party offering advice of counsel as a defense in the litigation. That was the distinction that I was making.
But they have done it. They said, look, we didn't tell the police commission because it was relying on advice.
Where in their answer or any pleading have they taken that position?
They just took it here in court.
I just did that, Your Honor. But the issue is whether or not that has any pertinence to this case whatsoever, and even if it does,
But
I
that's
don't
my point,
know.
you're not, it's not a defense to the case. You're saying it's irrelevant and it's not admissible evidence, but that's not a defense to the claim.
Right. If somehow it matters in this lawsuit, why the Tremblay report was shared with whom, then yes, Attorney Costello will need to explain to the court or the jury what his legal advice was. But I don't see how it matters.
All right, well, I'll mull this one over.
I would like to take you up on your invitation to submit additional authority on subsequent conduct, if I may, please.
How soon can you do it? Because this case seems to go on forever.
Well, it probably is going to go on forever, so I'd like at least 5 or 6 days to get that ticket. We've got an intervening holiday.
Oh, we do, you're right. It is Christmas, isn't it? I'm sure there's an objection from the other side, but I'm going to let him do it anyway. Tell me what works, given the holidays, what works for you. I don't know if you're traveling.
10 days from today would be fine, Your Honor.
That would actually be January 1st, so do you really do it the 2nd?
The 2nd would be great.
All right.
Thank you.
And any response?
Would we be allowed to file a response if so? I'd like to.
Of course. 10 days for you? 10 days, 10 days?
January 15th?
Let me just see if that's a weekday.
That's probably,
Yeah, that's fine.
that's probably less than 10 business days, but.
That's fine. January, let me make a note of this. And just to be clear, I understand the issue that you're proposing to brief is whether there can be a continuing violation after the termination in a fair employment practices claim or a public policy
Yes, Your Honor.
claim.
Or a conspiracy claim,
Right.
the 3 counts.
Okay.
I have a collateral inquiry,
Yes.
Your Honor.
Mhm.
Working from memory, and that's always dangerous at my age, but working from memory, I believe that the summary judgment deadline is January 15th.
Oh, okay.
And if we have ongoing disputes about what discovery is allowed and is going to be allowed, it's hard to do a last end of discovery summary judgment motion before the discovery is complete. So if we're going to have some additional rulings and additional depositions, the thought that goes through my mind is whether or not the summary judgment motion deadline should be extended.
So-
It really damages depositions, they'll be different, these are different scope.
Right. So what we've talked about right now is just lures being deposed, right?
Yes, Your Honor.
And I guess the Costello one is open based on this argument. Other than that, is there anything else outstanding that you would be seeking?
Not as far as the plaintiffs are concerned, Your Honor, and I don't see why. I mean, plaintiffs work really hard to meet every one of those deadlines in the pretrial report, and we have done so. I don't see why Mayor Loris's deposition should be caused to delay anything.
If Mayor Loris's depositions are relevant, then I'm not sure why we need it.
No. Anybody have any sense of how soon you can do that deposition?
I suspect we need a ruling from the court on its breadth and scope, and then,
I sort of did that early, but it sounds like you want one in writing.
well, this continuing violation issue, you're going to circle back into it. This is another attempt to depose Mayor Loris or somebody else on what happened after January 12th. And if something that happened after January of 2012 is somehow relevant, then it's going to come up at the mayor's deposition. So this is still another backdoor effort to make things after January 2012 somehow pertinent in discovery. So if, this continuing violation theory is going to be considered, then we don't know what the scope is yet.
Right. Well, I guess I would agree that it's kind of hard to do summary judgment when discovery is still going on, and we don't know. So how about if we move the summary judgment deadline? What did you say it is right now, January 15th? Is that what?
That's it.
I don't have that.
I just checked, that's what it is.
How about if we move it to March 1st on the theory that the court will try to get a quick ruling out and we'll have some time to do short depositions done? Does that sound reasonable?
That seems to contemplate that Mr. Costello will be deposed, in which case we will have to cross the bridge of where he's deposed. He's now in New York City.
Okay, yeah, I mean, obviously, if it can't be done, it can't be done. You can always ask me for more time, but right now, say March. Are there any other outstanding deadlines that we should also talk about?
Not that I'm aware.
What's up with mediation in this case? Did it happen? Is it scheduled?
It did.
It did happen. Okay. Mr. Fagan, what else?
The only other issue I had, Your Honor, is plaintiff had sought other complaints of racial harassment and racial profiling, and we think that it's certainly reasonably calculated to lead to discoverable information. It goes to the issue of notice, goes to the issue of what was done when these other complaints were received by the city, whether or not they were properly investigated, and we think that that's relevant. It goes to the defendant's state of knowledge, their state of mind.
Remind me, I thought, and again, with time, this is getting fuzzier, but my recollection was I didn't bar all discovery on that issue. I limited it because I thought your request was asking for overbroad, all oral, phone call, et cetera, et cetera.
I was asking for any other racial, complaints of racial harassment or profiling, however maintained by the city.
My memory is the same as yours, Your Honor. This goes back to January 2012. The court issued an order granting in part and denying in part a motion to compel. In February of 2012, I produced, I did a reduction in compliance with the court's order. And this is now in December raising the issue about adequacy of the February production. And we've been through a whole series of motion practice in the intervening time. I just think this is completely untimely.
You did receive some information about other complaints?
No.
So what are you saying you disclosed?
The court had a series of, the court's ruling on the motions to compel the protective order. That order had a series of paragraphs. The order itself. The first paragraph is granted in part, denied in part. Then it says the motion for protective orders is denied. And then it says paragraph 3, and it addresses records from personnel files. So on February 12th, I sent a letter to Attorney Fagan discussing the portions of the personnel files that came within that scope of the court's order on paragraph 3. The next paragraph, paragraph 4, order to produce within 30 days any portions of any internal investigation reports and detailed certain parameters. The next part of my letter is on paragraph 4 of the court's order, and I produced certain internal affairs reports, and then I itemized every internal affair report within the time frame the court gave for Johnson, Post, and Gina, so that if there was a disagreement about
Right, but I think we're talking about two different things.
and then, if I may,
Okay, go ahead.
it said in paragraph 5 was about dismissal cases, and then paragraph 6 is balanced motion to compel is denied. So I complied with the court's order at the time. The court denied the portion of the request to produce anything that somehow we waited to raise as being overbroad.
But wasn't there something, and I may be misremembering this, and I can't find all of this, because this file's got a little unreal. If the police department had received written reports from people in the community complaining that the police were, being discriminatory based on race, and there was documentation like that, that would be producible, I think.
If it's asked in the appropriate manner and so forth, then we have not taken the position that an appropriately tailored discovery question on that subject is off about. No, we haven't taken that position at all. We have attempted to comply with the discovery request, and where they seemed to be appropriately tailored responding. We had a motion practice, a year ago on this, and at that position, there has not been a single question related to race that has not been answered. So this is an effort to go back and revisit the court's ruling in January of 20.
Well, I guess, yeah, I'm looking at the motion, I'm looking at my ruling from July 15th, which is the one that this motion to reconsider is directed at. And I'm not sure what portion of it we're focusing on here. And perhaps you can clarify that for me, Mr. Fagan.
So part of it, Your Honor, was that after Post and Johnson were no longer with the city, there was a series of cases that were all dismissed. Actually, all of Post and Johnson cases were dismissed. We were looking to get the identity of those cases as well as any written complaints having to do with racial harassment or discrimination.
I think he's right, though, that's not this July ruling, is it? I don't see anything in here about that.
That's the January ruling.
I mean, I think that's come and gone. This July ruling wasn't on that topic.
Well, I thought it was in connection with this order that you were continuing, that we couldn't have any discovery after January of 12, and we know those cases were dismissed after January of 12.
That's not accurate, but anyway, we're
Okay.
re-arguing in January.
I agree, because I'm looking at my ruling from July. The first section was about the city's request for a protective order with regard to deposition notices for Loris and Costello. In the context of that, I talked about the January 2012 termination, constructive termination, and that's the only place it seems to appear in this ruling. I don't believe this issue of prior complaints about race was raised at this time. I certainly am not saying that I talked about it in here at all. So I don't think I can go back and revisit something that wasn't actually the subject of this ruling at this point. Anything else that we haven't addressed?
It's not totally clear to me, Your Honor, where we stand with respect to the portions of the Tremblay investigations that were redacted.
Is that even on the table today?
Uh,
And if so, why?
I just want to make sure I know what my obligations are, Your Honor.
I don't remember what I've said about that in the past. I think I addressed it.
Oh, yes, you've addressed it several times.
And so why is it an issue again, I guess, is my question.
It keeps coming up.
Was I not clear enough, and do I need to be clearer? That may be the case, but what's unclear?
For the sake of clarity, we're hearing Attorney Fagan talking at length about the reports. And it seems to be that he's requesting the fully unredacted versions, though I haven't really seen that in writing. On page 3 of your July order, Your Honor, you state he also fails even to address the issue of the internal affairs report. So the motion is also granted on that issue. So I think it's a closed issue. And the one sort of contextual thing I wanted to say to the court is that it's important, the court is aware, we've got to keep in mind that this is a request for reconsideration. So I haven't heard anything as to the standard on a request for reconsideration that the court missed any law. I haven't heard that the court missed any facts from the law. So, I think that this is basically a closed deal at this point.
And I don't believe in your motion you raised the issue of the redactions again.
I did not.
Okay, so I guess we are all in agreement that that one's closed for now.
Well, as long as they're not raising the issue that those acts did not occur, I agree with you. But if they raise the issue, if they dispute or say that the plaintiff was not accurate in making those complaints, then I can see how that information may then be unredacted for purposes of meeting that.
I guess based on our earlier conversation, if they throw that topic into the case, they might be opening something, but.
This is perhaps the nuance, but as I understand it, the plaintiff would say, I raised these allegations, these
Right.
issues. Whether those allegations are true or not isn't the issue. It's not that.
And that's what I've been saying all along, but as I said earlier, if you guys somehow started injecting into the case, they're not true, he's a liar,
Right.
that might change things.
But there's a flip side to this, too. I don't think that Attorney Fagan should be allowed to put on hours of evidence about his client or other people and what they saw and why it's so true that my allegations are so true. It's got nothing to do with it. Just,
Well,
okay, this is what I complained about, we're done.
Let's worry about that when we're getting ready for trial. I'm not sure I can predict all of that now. Okay, so let's just be clear then. Motion response, Mr. Fagan, you're willing to waive or apply in the interest of moving this along?
Pardon?
Are you willing to decline to file a reply on this little round of filings?
Except for the issue you did allow me to file on the.
Right, now what I'm saying is normally there'd be a memo from you, I guess it's not a new motion, so if it were a new motion, there'd be a memo, a response, and a reply, and I just want to be clear, we're just going to have one filing from each side.
Yes, Your Honor, I
Okay.
understood that.
Okay, So then that will lead either to 1 or 2 more depositions at most, and motions by March 1st. What's the trial ready deadline right now in your current schedule? Does anyone remember?
I want to say June, but
I'm looking right now, but I thought it was more spring, Judge.
I mean, it depends obviously when the motion is resolved, but bottom line, it'll be whenever the motion for summary judgment is resolved, it will be considered trial ready. Fair enough? Okay. Are you expecting to file cross motions? Has anyone thought about that? Obviously, they are planning to file a motion.
yes, Your Honor.
Okay.
We would view the March 1st deadline as applicable to our motion as well.
Okay, so you both file on the same day and then respond to each other's.
But we would have, I think, 15 days under the rule to file once we receive theirs.
You each get 30 days to respond to each other's, actually.
So if I could have to April 1st then to file any responsive motion.
I'm sorry. So what I'm understanding is you're both going to file any motions for there are 3 lawyers. All file your motions for summary judgment by March 1st, unless I change that date. You then, each of you would have the 30-day period to file your responses to each other's motions.
Yeah.
Okay? And then there is a reply time that applies to that too, so at that point, we're getting close to May.
Just to be clear, Your Honor, there's 1 or 2 more depositions on these factual issues, liability issues that Attorney Baker wants to conduct. I've got one, maybe a couple of damages depositions that I still want to conduct, and we'll have time to do that.
And you guys are working that all out? There are no fights over any of that?
First, I've heard they want to take depositions, but we usually do work that out.
Okay. Who do you want to take?
We deposed 1 person from the state with regard to his current remuneration package. It looks like we have another person to depose. I'm trying to get some of the additional details as to the scope of his present remuneration package so it can be compared to the past one.
Right. So this is another person from the state?
Correct.
That you don't know who yet?
The first person we spoke to gave me the name of somebody else. I sent an email to the Assistant Attorney General who was at the deposition, asking if that's the right person, and if so, when can we do this deposition, et cetera, and I haven't heard back.
Okay. But you don't object to the deposition, Mr. Baker?
As long as it's timely under the order, no, Your Honor.
Okay. All right, anything else we can address today? Great, and thank you all very much.
Thank you.
Thanks, Judge.
Ready to start?
Happy holidays, everyone.
Thank you.